We will now dwell into the case of Gasataya versus Mabasa, GR number 148147, promulgated on February 16, 2007. Facts about the case. Buenaventura Mabasa was granted the homestead patent for lots 279, 272, and 972. He mortgaged the lots to acquire a loan from the Developmental Bank of the Philippines, but failed to pay his loan, and so the DBP reacquired the lots. His daughter, after his death, repurchased the properties through the deed of conditional sale for 25,875.3 pesos. Subsequently, Edita made an agreement with Sabas Gasataya that the latter would pay 10,000 to Edita and 25,000 to DBP on her name. As Edita's obligation to DBP was settled, they entered into another agreement, which was the deed of sale of fish pond lands with right to repurchase.
8 years after the execution of the said agreement, it was discovered that Sabas Gasataya stopped paying at DBP, which resulted to the revocation of Mabasa's right to repurchase the said lots. Later on, DBP held a public auction of the land where the petitioner participated and bid the highest price of 27,200 pesos. Gasataya was able to get the titles of lots. Mabasa then filed a complaint on the Regional Trial Court for the reconveyance of the land titles with damages against Gasataya. She claimed that the latter intentionally reneged on his commitment to pay DBP to revoke her right to repurchase the lots under the deed of conditional sale, and to subject the properties to another public auction where petitioner could bid.
In accordance with the ruling, the judgment was in favor to the respondents against the petitioners, therefore ordering the petitioners to return the said lots to the respondents and are upon legal tender issued by the petitioner that amounts to 37,200 pesos, transfer certificates of title and award them to the respondent, return the physical possessions and occupancy of the said lots to the respondents as per the certificate of title, payment to the respondents in forms of cash that amounts to 5,000 pesos for attorney's fees and legal action expenses, and an additional payment by the petitioners for the cost of proceedings. Meanwhile, the petitioners appealed to the Court of Appeals, which were then dismissed on the grounds that they lacked evidence to corroborate with their claims.
Gasataya has the possession of the land because of the deed of sale and not by the DBP. He also committed a breach of trust amounting to fraud. It is because of him not paying the DBP and joining the public bidding so he can own the lot not only for 20 years. A conveyance is available not only to the legal owner of a property but also to the person with the better right. Mabasa has the better right because she was the one who coordinated with the legal owner while Gasataya was only given a possession because of their deal. The right to repurchase would have been subsisted if Gasataya did not defrauded her.
The trial court's findings as affirmed by the CA that petitioner and his father deceived the respondent to acquire the disputed lots. Petitioner insists that respondent had no right to the disputed lots since the conditional sale agreement had long been cancelled by DBP. According to the petitioner, a void and inexistent deed cannot override his right as registered owner of the lots. We disagree. Petitioner cannot discredit the deed of conditional sale just so he can keep his titles to the lots. Petitioner should be reminded that DBP revoked the respondent's right to repurchase the lots under the said deed because of the deceitful schemes that he and his father employed. Fraud throws the presumption that the public sale was attended with regularity.
Given that the fraud preceded such event, the properties in Gasataya's name is voided. This is seen through his act that the respondent's obligation to DBP was settled. Consequently, fraud is a ground for reconveyance. The law only protects an innocent purchaser for value, and petitioner was not. To conclude, the court takes note that Edita originally acquired the lots through homestead grant. Commonwealth Act 141 aims to preserve the ownership of the lots to the homesteader and his kin. Hence, we agree with the CA's decision. According to the CA, desperation does not allow much of a choice, hence they should be given every opportunity to repurchase their land. The decision of the Court of Appeals in GRCV number 5505 is hereby affirmed and cause were filed against petitioner.